Hey guys, and welcome to the Weekly Docket. Let's start in Wisconsin with the guy everybody loves to hate, Darrell Brooks. He should be feeling better about the justice system these days. He never stopped reminding everyone he hates a rush to judgment. So the news his trial transcript has been delayed again, this time until July 10th, should make him feel more at ease knowing there's no rush to judgment on getting these done. And he needs those to start his appeal. In other news, an order to produce has been issued in one of his cases. That's to prepare him for transport to the final pretrial conference later this month for one set of his cases. Prison staff will surely get his wheelchair wheels greased up and ready to roll. Darrell, nobody tells me what to do, but I get told literally when I can eat, sleep, and leave a tiny box, and when I'm in court, I'm strapped to a wheelchair as mobile as a hand truck loaded with an old broken refrigerator. Brooks to his hearing. Let's head out west to Idaho. At the time I'm recording this, waiting for Lori Vallow's case to be handed to the jury for their decision. I think the outcome there is pretty clear. She is evil. Let's get off of that case because what really is there to talk about other than how bad she is? She's definitely guilty, and with the death penalty off the table, it is what it is. In the Bryan Kohberger case, however, the judge is teeing up the motions by a victim's family attorney and the media to vacate or modify the gag order. The court has set a scheduling conference for the motion for May 22nd. Now, the media doesn't like this, and they've asked the court to move that date up, saying they have irreparable harm every day due to the hampering of the reporting they want to do. And if they wait until the 22nd, that means they won't even get the briefing schedule ready or the actual consideration of the motion until sometime later than that in the future. I think I said in the last video the judge could slow roll this situation some by taking it under advisement before issuing an order. And punting this thing into June hearing is a good way to get that started. So you do a scheduling conference on the 22nd, you set it for sometime later than that, and the briefs come in and all that. It's possible she might even try and kick this thing far off enough that it comes after the preliminary hearing for Kohberger. That would be pretty extreme, but it might be what's going to happen. We'll see. Now, nobody should be a fan of gag orders in general. They should only be issued when necessary and to the most limited degree possible. This one has, to my mind, though, been blown out of proportion with some people maybe deliberately acting like they can't read its provisions. Having said that, the media does have an argument about the factual record development to support this order because it has to be shown as necessary, and perhaps the scope and the clarity of the order as well. That's why I think when the smoke settles in June or whatever, this order gets modified. I said I think that probably will happen in the last video. I still stand by that. I don't think it's going to stay exactly the same, and I don't think there's going to be no gag order. I did see at least some additional media, and here talking about law and crime in the form of Anjanette Levy, decry the gag order, which is understandable. But she also said this: the overly restrictive gag order is handing the defense a potential appellate issue. I like Anjanette and I appreciate her work, but what? Kohberger is in favor of the order. Kohberger wants this order. Kohberger just this week filed opposition to the media request to even try to speed things up. Kohberger's attorney says this court has reasonably and correctly recognized that the proper path forward is a hearing where the parties may show what evidence there is of prejudice and the potential for prejudice to Mr. Kohberger's 6th and 14th Amendment rights to a fair trial from the removal of the non-dissemination order in this case. So he's saying his rights will be prejudiced if they were to remove this order. Law and crime is saying that his rights are prejudiced if she leaves the order there. Kohberger goes on to say, because the media coverage of this case has been intense, and because Mr. Kohberger plans on providing expert testimony on its damaging effects, Mr. Kohberger will require additional time. He's not going to be prepared for the hearing on May 22nd. So he doesn't want the order to be modified, and he doesn't want to hear about it any more quickly than is necessary because he wants to have experts talk about how if this order were removed, how the whole thing would be unfair to him. But law and crime has said if it doesn't get removed, that would be unfair to him. So here's an order Kohberger wants, intends to defend in court with expert witnesses, And Law and Crime is saying it has an appeal issue if the court doesn't get rid of it. Remember, the point of the order in this case is to ensure a fair trial by tamping down jury tainting publicity. Kohberger is for that. So under what logic would continuing an order designed to protect Kohberger, requested by Kohberger, argued for by Kohberger, be an appeal issue for Kohberger if she were to keep it? That doesn't make any sense, right? Let's keep it real, people. I know the media is against the order, but let's just keep it real. This case is really driving some strange social media takes, and this to me is one from an unexpected source. Let's get out of Idaho, get out of town, and get down to Florida. Remember Judge Scherer of school shooter Nicholas Cruz's death penalty hearing circus fame? She's resigning. She says that's been in the works, and best of luck to her in her next endeavor. On the legal front, Jeffrey Epstein's name is in the news again. Now, the Court of Appeals there has opened the door to potentially releasing information from the grand jury in his case in the interest of furthering justice. There was excellent reporting that he received a sweetheart deal on the one conviction that he did get a long time ago that vastly underprosecuted him while at the same time insulating him and others from further scrutiny. The reporting certainly convinced me. If true, it's really disgusting. Grand jury material could shed light on whether the justice system acted in such a despicable manner. Yes, grand jury stuff is typically very secret, but there are exceptions. The Court of Appeals has said this may be one. It has certified a question to the Florida Supreme Court, and assuming this sticks, we'll send it back down to the trial judge for hearing on this. I'd probably be a little nervous if I were that trial judge. It seems like there's a lot of rot buried in this case, and maybe someday the truth is going to come out, but there is a lot of power against that. All right, let's go to New York and finish on something that's it's a little serious, but not really, not compared to what we've just been talking about. So New York is a place where much is tolerated by the unhoused. Shoplifting, assaults, harassment, battery, all these can be overlooked in deference to the plight the unhoused face. Unhoused, that's better than homeless, right? I think I've been told that. I don't care why. The trend of changing terms to signify the latest version of sensitivity is more grating than having to update iOS on your iPhone every week. So I'm just going to go back to homeless. If dude doesn't have a home, I'm going to call him homeless. I'm not insulting him. Apparently that's a fact. Anyway, so there's a homeless guy there who decided he needed to defecate ASAP. And he was on the sidewalk and decided to grab 2 nearby pieces of cloth at a little restaurant shelter, one of those things they built there that was going to save everybody from COVID, I guess. Well, he got one on which he launched the discharge and contained it onto this piece of cloth. He didn't just scatter things all over the place. And one he used for personal hygiene after that. But these weren't ordinary pieces of cloth. These were imprinted with the logo of, I'm not sure I'm going to get this right, LGBTQIA2A++. It could be a later or earlier version of it. That thing also updates more frequently than an iPhone. Well, that's something that can't be overlooked. So he's been charged with hate crimes. The ultra woke restaurateur really said this about the African-American Residents Challenge number 2 enthusiast. He could have gone to Popeyes or McDonald's around the corner. How tolerant. I mean, can you believe? I can believe it, okay? So the story's not over. This guy presents to a defense attorney, whoever is awarded the honor of representing this gentleman, the rare opportunity to stand up and say with 100% confidence, Your Honor, my client is innocent. I don't like criminals, and even I would stand up for this man and say, Your Honor, he is innocent. And that's because this guy's name is Fred Innocent. Can this planet get any stranger? Anyway, that's it for this week. Thanks. Bye.